We're on the record. Today is November the 7th, 2018. The time is 12:12 p.m. This is the videotape deposition of Lieutenant Bradley Morefield in the matter of Elder Flores versus City of Houston, Texas, et al. In the United States District Court, Southern District of Texas. This deposition is being held at 901 Bagley Street, 3rd floor, Houston, Texas. My name is Charles Caleb Jr. and I'm the videographer. I'm present on behalf of Stratus Legal. The court reporter is Michelle Hartman, also present on behalf of Stratus Legal. Counsel now state their appearance and firm affiliation for the record.
U.A. Lewis for plaintiff Elder Flores.
Shirley Parker for plaintiff Elder Flores.
Kimberly Clark for La Estancia Apartments and 2012 Multi-Family Real Estate Fund.
Jim Butt on behalf of the city defendants, and I'd like to read and sign.
Will the court reporter please swear in the witness?
Do you solemnly swear or affirm in the cause now pending to tell the truth, the whole truth, and nothing but the truth?
I do.
We may proceed.
Okay. Good afternoon, Lieutenant Morefield. As you know, this is a continuation from our previous deposition, and I'm going to give you what's marked as Exhibit Number 1, and it's the notice of deposition. Are you familiar with that notice?
Good afternoon. Yes, I am.
Okay, thank you. And I'm going to go ahead and continue on, and we'll get back to that. I'll go ahead and continue on with the deposition as we left off. What was that, on the 28th? No. Anyways, 26th, I believe it was. But can you tell us, as it relates to an investigation with HPD, after a shooting is involved, or officers involved in the shooting, can you tell me if HPD receives any evidence from the district attorney's office? I know that you guys provide evidence to the district attorney's office. Is there any information that's provided from the DA's office to HPD to help with their internal affairs investigation?
I guess that would be on a case-by-case specific basis, but I don't know of any practice that would call for that.
Okay. And the Internal Affairs Department, it gathers evidence that it receives from the Homicide Department. Is that right? That's a different department, right? Homicide and IAD?
There are different divisions within the Houston
okay.
Police Department, yes.
Okay. And Internal Affairs, they actually receive evidence from the Homicide Division, correct?
I guess it depends on what you're determining as evidence. If you're talking about evidence as in the bullets on the scene, I don't think the Internal Affairs Division receives the bullets from the scene.
All right. What about statements and just any type of information that when I say they, IAD needs to help with their investigation? Are they able to collect that information or evidence from the Homicide Division?
Internal Affairs does receive statements from the Homicide Division.
Okay.
Yes.
What about any other evidence? Is that the only evidence?
Internal Affairs receives what they call a pink back from Homicide Division, which is a collection of statements that the Homicide Division collects. It could include diagrams of the scene. Obviously, the offense report that describes the incident. And I don't know of any other evidence that...
What about like forensic evidence, fingerprints, blood evidence, anything like that?
Well, the forensic evidence would be notated in the offense report.
Okay.
But the actual fingerprints, I don't believe are provided to the Internal Affairs Division.
Okay. And does it work in reverse? Does if the Internal Affairs Department gathers information, statements, or any type of evidence, do they in turn share that with the homicide investigation team?
No, they do not. They cannot under the law.
Okay. And under what law?
Well, if the Houston Police Department compels an employee to respond to an internal affairs investigation, which is just about every statement that the Internal Affairs Division takes, then that statement is protected by case law under what is just generally referred to as Garrity.
The Garrity, okay. And so you're saying that the Internal Affairs Department can compel testimony and information from the officer that they're investigating?
For use in the administrative investigation, yes, they can compel a statement.
Okay. Okay, so they only can compel a statement, correct?
As opposed to what else?
Any other type of evidence?
I mean, it's going to be case specific again. There may be certain situations where they may be able to compel an inspection of the work area, which could yield evidence, phone records, but again, it's going to be case specific.
Okay. And what about sharing information with the DA's office? Does the Internal Affairs Department do that at all?
Sharing information, no, because Internal Affairs collects it under the Garrity protection.
So again, the Garrity. So there's no interaction with the Internal Affairs Department and the grand jury. Is that right?
Internal Affairs and the grand jury?
Yes.
I'm not aware of any.
Okay. So when an officer's involved in a shooting, oftentimes those shootings are referred to the grand jury at the hands of the district attorney's office, correct?
Can I go back and clarify
Sure.
a question? So, as I understand criminal law and Garrity, there may be limited circumstances where a compelled statement may be used in criminal law. So I cannot say that there has never been internal affairs information that has been shared with the DA's office.
Okay. And the is there a time when well, does the Internal Affairs Department share other evidence besides the statements with the district attorney's office, and within the context of the presenting the information to the grand jury?
No, that's not within the purview of the Internal Affairs Division.
Okay. Who is it at the City of Houston, at the Houston Police Department, that does provide information to the grand jury after a shooting?
That would be if the DA's office calls a homicide detective from the Homicide Division to testify in front of the grand jury.
Okay. And so the DA would have to call and ask for a homicide detective to testify before the grand jury? It's not just automatically provided to them, the evidence that they've collected and information?
Oh, sure. The evidence collected by the Homicide Division is automatically shared with the DA's office, absolutely.
What about for the grand jury proceedings?
That would be up to the prosecutor.
Okay. Now, does the Internal Affairs Department ever rely on information that they have received from the district attorney's office that they've presented to the grand jury?
I don't know of a case where that has occurred, but it would be fine to do that.
Okay. And is sometimes the case where since you said sometimes they do, sometimes you don't know of any case, is it sometimes or oftentimes the case, I guess, where the grand jury's findings and the internal affairs findings might not be consistent?
Well, you're talking about proving up two different things. The grand jury is looking at whether to indict on a criminal charge, and the Internal Affairs Division is determining administrative citations or potential violations of department policy. So I can't compare them apples to apples in that sense.
Okay. And when I say their findings might be inconsistent, meaning the end result from a grand jury would be obviously indictment, and the end result from an internal affair, if there's a finding, would be discipline. Is there often times where a grand jury might find that a person should not be indicted, but internal affairs finds that they should be disciplined? Does that happen?
I don't know if it's oftentimes, but yes, it does happen.
Okay. And does it happen where an internal affairs investigation might find that there's no discipline warranted, but a grand jury would still indict the person? Do you find those type of final determinations?
Do I find them?
Have you found them, I should say?
I cannot recall a case where that has occurred.
Okay. So usually if a if a person is found to be discipline is warranted through the Internal Affairs Department, that doesn't mean that doesn't mean that they'll be indicted, correct?
No, I mean, they may be disciplined for administrative violation that may or may not be related to the actions that the grand jury is looking at for a potential charge.
Okay. And there's times where a grand jury might find they should be indicted, but the Internal Affairs Department will not find that there's discipline, correct?
Well, the Internal Affairs Division makes recommendations on whether a citation would be sustained. They don't make a determination on discipline.
Okay. And so the citation, what is a citation? Explain that to me, I'm sorry.
Sure, a citation is a final determination by the Internal Affairs Division, ultimately by the Chief of Police, as to whether an officer has violated a part of department policy or has administratively, or there's been an administrative finding that the officer has violated some type of law or ordinance.
Okay. All right. So, to use the proper verbiage, is there times where a grand jury might indict an officer, but a citation won't be, would not be warranted by IED?
I can't think of a time when that's happened.
Okay. But there, again, now that I have the proper verbiage, there are times where citation might be warranted, but an indictment may not, correct?
Correct.
Okay. And that that's based on the same activity or the same conduct and actions, correct?
It could be, yes.
Okay. Do you know of any instances where a person has been no-billed by the grand jury but still was disciplined by IAD or issued, or I guess citation was the proper outcome after the grand jury has found that they should be no-billed?
I believe in the Officer Coronado shooting that we spoke about earlier in this
Right.
deposition. His case would have gone to the grand jury, and to the best of my recollection, the grand jury did not take any action.
Mm-hmm.
They no-billed him, but he still received departmental citations of misconduct.
Okay. And is there any others?
I'm sure there's plenty of cases. I just can't recall cases right off the top of my head.
Okay. And you think that there are others where there was a no-bill, but there was actually a discipline or a citation directed towards the officers?
Yes.
Okay. Do you, you stated Coronado, and you said that you cannot recall any others, though, correct?
I cannot recall specific cases.
Okay. And what do you mean by you can't recall specific cases? Is there details that you can recall?
No, I just remember generally that there have been other cases where officers have been no-billed by the grand jury, but the department did find citations of misconduct against them in the internal affairs investigation.
Okay. Okay. And it's true when an IAD investigation is going forward that officers that are being investigated receive a copy of all the statements that have been gathered by internal affairs, evidence, and including witness statements prior to their own interrogation, correct?
That was generally the practice at the time of this shooting under review.
Okay. And officers do get to respond in writing, correct? They don't have to actually give an interview. Isn't that true?
At the time of this shooting, the practice was that officers would respond in writing.
Okay. And can you describe the process of the written statement by the officers? How are they offered the opportunity? How is it responded? What type of setting is it? Can you just give me an idea of like the process of the written statement?
Sure. So the written statement and the time that the officer is given to complete the written statement is meant to comply with Chapter 143 of the Texas Local Government Code and the provisions of the Meet-Confer Agreement. And so when the internal affairs investigator believes it's time to bring the officer in other words, they've collected the statements and evidence necessary to question the officer, they will order the officer in to meet with the investigator at the Internal Affairs Division. And again, in order to comply with law, policy, and the Meet and Confer, they will give the Internal Affairs Investigator will give that officer what's called a 48-hour notice, which is provided for in the law. The officer is entitled to take 48 hours to consider the areas that the department is ordering the employee to respond to.
Okay.
That will be reduced to a document that's given by the investigator to the officer, and the officer will take that document and they will have to come back at the time set by the Internal Affairs Division and have their response already prepared to turn in to the Internal Affairs Investigator.
Okay. And it's only the officers that are subject to the internal affairs investigations that are allowed that opportunity, correct?
Which opportunity?
To provide a written statement, the 48 hours, and come back and...
I mean, it could be the officer who is the subject of the complaint, but also the witness officers who are also involved in the investigation. They are also afforded the 48-hour notice.
Okay, and why is that?
Well, it is provided for in the law, in the sense that any information that the department comes across could result in a complaint against another officer.
Mm-hmm.
And so, in an abundance of caution, the department offers the 48-hour notice to any witness officer because they could potentially respond with information that also makes them a subject of either that particular investigation or another investigation.
So it's to protect the officer. IAD gives this opportunity to a witness officer who's not a subject to the complaint, the same opportunity as they would an officer that is subject to the complaint, in order to protect that officer to have the same, the same type of protection as the officer that is subject to the complaint, correct?
It's not to protect the witness officer, it's in order to comply with the law, because if the department violates the law in that circumstance, they will lose the ability to use that statement at a later date if the case goes to a hearing.
Right, but the law does not provide that witnesses should be able to be provided 48 hours to make a statement and return it. Isn't that true?
The law does not specifically require that witnesses be given the 48 hours, but again, that witness officer could become a target, and therefore, in order to be able to preserve the ability to pursue a complaint against that witness officer, the 48-hour notice is provided to that witness officer.
Is a witness officer also compelled to make a statement?
Yes.
And is that where that's pursuant to Chapter 143 as well?
The ability to compel an employee?
No, the witness officer to compel a statement from a witness officer, if they decided they didn't want to they decided to opt out and did not want to provide a statement, is that opportunity afforded to them?
No, well, they can do it, but it would be under pain of insubordination. And to answer your question, it's not so much Chapter 143 of the Texas Local Government Code. It is, as I understand, employment law as it applies to public employees.
And explain that to me, your understanding.
Sure. So, as I understand it, the Garrity protection applies to public employees if they're given notice that they must submit to an interrogation, and they're given notice that failure to do so would result in insubordination. Then they have protection that statement would not be used on the criminal side, but they must give a statement or otherwise potentially face insubordination.
But that's when they're subject of the investigation, correct?
Well, no. As I understand, it applies to any employee that we compel a statement from.
Okay. So all employees, even complaining witness employees, they're able to look at all the witness statements from other witnesses, and also from the subject, the employee that's subject of the complaint, and they get 48 hours, correct? To respond to that, correct?
When you say the complaining witness, you're talking about a complainant, the person who initiated the complaint?
Correct. Mm-hmm.
Well, many times they lodge their complaint, and then there's no reason to go back and ask them additional questions, so a 48-hour notice would not be needed.
But if it was needed, they're allowed to get all the information, correct? And you have to give them all the information in all the other statements, correct?
Absolutely. They
Okay.
would be given all the statements.
Okay. And is it the chief of police that makes the ultimate decisions on whether an officer that's involved in a shooting is disciplined or not?
Yes.
Okay. And is it the chief of police that also is the person that makes the final determination whether the shooting or the investigation is found to be justified or not?
Yes.
Okay. And so the chief of police is also made aware of all shootings, correct?
Yes.
Okay. And was the chief of police in this instance made aware of Mr. Flores being shot by Officer Harris?
I don't know specifically.
Okay. Why don't you know that?
Well, I can say that is the practice, but I can't testify that that actually occurred. I wasn't there. I didn't hear about it. I don't know for sure.
Right, but you know you're here as the city of Houston, so do you know whether the chief of police, whether protocol was followed in this case?
I don't. That's what I'm saying. I do not know.
Okay. All right. And as far as who exactly was the chief of police in 2015? I know that was a strange period. I think McClendon had retired or was about to retire.
I think Charles McClellan was still
Okay.
the chief. Yes.
Okay. Okay. And if protocol was followed, he would have made the final decision as to whether Harris, in this case, was disciplined or not, correct?
That's correct.
And he also would have been the one to determine whether the shooting was justified or not, correct?
That's correct.
Okay. And do you know whether any of the internal affair investigators are ever summoned to appear before the grand jury to provide testimony?
I do not recall ever hearing that happen.
Okay. And as far as homicide is concerned, are any homicide division officers summoned to provide testimony? I think you said something to that effect earlier.
Yes, I'm sure they are.
Okay. And who is it is there usually a representative that's sent, or the person who's investigating? Who exactly is it that is sent over?
I'm not really sure. I would think it could be either the lead investigator or maybe the supervisor of the lead investigator. I'm not sure.
Okay. And are you aware of a program called the Personnel Concerns Program, PCP?
I am.
Okay. Can you tell us about that program?
Sure. At the time of the shooting in this lawsuit, it was called the Personnel Concerns Program and is now called the Early Warning System.
Okay.
It is a mechanism by which the Houston Police Department can become aware of employees that they may have a number of complaints in their internal affairs file. There may be performance deficiencies. And if the employee that they're looking at, if that employee meets criteria to enter the Personnel Concerns Program, then they will be placed in that program, and it's a very rigorous program. At that time, it was, I believe, 240 program days, which could take about a year to go through the whole program, where they're looked at very closely every single day by their supervisor. The supervisor has to complete paperwork daily on the employee's progress throughout the program. And it's a way that we can hopefully, when I say we, the department, can hopefully get an officer's career back on track.
And the early, so now when did it change over to the early warning system title?
It has probably been within the last year, maybe 2 years.
Okay. And the officers that are in the program, PCP back then, and early warning system now, is it EWS? Do you guys have the acronym for that?
I believe it's EWS.
Okay. So an officer that's in that program, what is their normal work schedule like at that point? Do they can maintain their normal schedule? Is this above and beyond? How does that 240 days work?
They maintain the assignment that they have at the time.
Okay.
And so, for instance, a patrol officer on evening shift would stay on evening shift at his regular assignment, and then his sergeant would just be assigned the extra duty of having to complete the personnel concerns paperwork.
Okay. And, okay, so I understand. So, are these officers, are they, so this is kind of punitive, it sounds like to me. It's sort of punitive type of measure taken against the officers, but to get them back into a regular structure and I guess.
It's not punitive in the sense it's not discipline.
Okay.
But it is a way to, we have uncovered some issues in their career. We want to get them back on track, and if that cannot happen, then the department may move towards indefinite suspension or termination.
Okay. And are the officers allowed to continue doing any type of extra jobs during that time if they are in the program?
As I recall from the policy, I do not believe they're supposed to work extra employment.
Okay. And what type of, is there some sort of alert system to say, hey, this person's in the PCP, so we can't, grant this permit? What is the system in place to make sure that if this individual that might be seeking an extra job permit is I guess, denied the opportunity, for lack of better words?
So an employee who desires to work extra employment will have to go into the extra employment system and file for a permit.
Okay.
That goes to their direct supervisor. So their direct supervisor is doing the personnel concerns paperwork, so they would receive notification
Got
of the
it.
extra job
Okay.
permit.
All right. And you stated before that the Internal Affairs Department, they don't rely on any grand jury findings in their investigation, correct?
I I believe when we talked about that before, I believe I had said that it could end up being a factor in the final determination.
Okay. And let's see. When an officer is preparing their written statement, they're allowed to consult with attorneys in doing so, correct?
Yes.
Okay. And let's see. But when they're dealing with the grand jury, they're not allowed to have any attorney inside of the grand jury proceedings with them, correct?
I'm really not aware of the grand jury procedures.
Okay, I understand. That's fine. Okay. All right. So after the PCP program, is there some sort of test or some sort of mechanism to see whether or not the officer, I guess, should continue the program? I mean, what is the litmus test on whether the program was successful, I guess, or not with an officer?
Sure. So there is a unit that is dedicated to reviewing the paperwork that the direct supervisor is completing on the employee. And for each employee, that unit will work up a set of goals, basically like a management plan. These are the goals you have to attain in order to get off the program.
Okay. And so when an officer is placed in this program, the 240 days, are those consecutive days?
No, it's program days. So if an officer, doesn't come to work because of vacation or calling in sick, that day's not going to count.
Okay. And you said there's a unit that receives paperwork. What unit is that?
It was the Personnel Concerns Unit.
Okay, so there's an actual unit where officers are dedicated just to work in PCP, or now EWS, is that right?
That's correct.
Okay. And so is that their full-time jobs to just work in this unit and review paperwork and find out, I guess, who needs to be in the program?
Yes.
Okay. And was Officer Harris or Mahood, were they ever recommended for the program?
I'm not aware of whether they were or not.
Okay. Do you know whether they were ever in the program?
I do not know.
Okay. Is this considered a type of, is this a training? The program, the PCP and EWS, are those considered a type of training? What's special about this program?
I guess what's special about it is that it's looking for officers that have concerning things in their record, whether it be performance deficiencies or a number of complaints, and then the Personnel Concerns Unit will hone in and actually do a deep dive into the complaints or the performance deficiencies so that a final determination can be made as to whether to place that officer in the unit. Into the program.
Okay. And so the PCP program, from my understanding, it identifies officers with complaint issues or complaint history, negative, I guess, what can be construed as negative behavior patterns. Is that right?
Yeah, it could be construed negative behavior, sure.
Okay. And do you know how many officers are actually in the program currently?
Currently, I do not know.
Okay. Is it a highly utilized program?
I guess it depends on what you determine as highly utilized.
Okay. Well, I would say not necessarily what I would determine as highly utilized, but does the department refer percentage-wise of all the officers on the force, there's about 550,000 officers on the force, is that right?
There's currently about 5,200 officers.
Okay. And of the 5,200 officers, about how many are in the program?
I don't know an exact number.
Okay. How many have been through the program, do you know?
That I don't know.
Okay. All right. And I kind of danced around that question before. I'm sorry I didn't get that answer from you. Is this considered a type of training?
I mean, I guess you could consider it training because there's those specific goals, the specific measures that the officer has to attain, and they're being very closely monitored, and we expect them to correct their behavior and for the supervisor to correct behavior, monitor behavior. So I could see it being considered training.
So do these officers, are they still, when they're working on their regular assignment, are they still with their partner that they're normally with?
If I recall correctly, I think the sergeant actually has to ride with the officer on
Okay.
patrol.
Okay, got it. That was my next question, so thank you. Okay. And you're not certain whether Harris or Mahood were afforded that opportunity, correct?
I'm not certain.
May object to ask and answer.
Okay, sorry. Okay. Now, as far as working extra jobs as an officer, explain to me the process on how a person who's employed with the Houston Police Department as an officer can obtain work in an extra job.
Sure. So officers hear about extra employment, usually from other officers, and if they desire to work extra employment, then, as I stated before, they have to file a permit with the department. It has to be approved by their direct supervisor. That permit will then be reviewed by the extra employment office, where we have a number of employees that review the permits and ensure that the places where officers are working are not prohibited by policy.
Okay.
And officers must comply with the policies regarding extra employment.
Okay. And when a supervisor is looking to approve an extra job, what exactly are they looking for to approve or not approve, seeing that another department checks out the actual employer?
Sure. Well, something that the direct supervisor may know that may not be immediately apparent to the extra employment office is if the officer is seeking to work a location in the area where there have been many problems, or which may be considered to be recommended to be a prohibited location.
Okay.
And so the direct supervisor would be looking for, is it a permanent extra job? Is it a temporary? What's the location? Is there a coordinator for the job? And what are the duties of the officer while there?
Okay. And what's the circumstance when a supervisor might say that they're not going to approve this extra job that their person in their unit is requesting?
Sure. It could be a brand new club that's opened up in the area, and the supervisor has come to realize that it's an after-hours club, and after-hours clubs are prohibited, or officers are prohibited by policy by working after-hours clubs, and the supervisor could deny the permit based on that.
Okay. And what about, there's no denial based on the officer's prior conduct?
If the officer, yes, if the officer had been ordered by the chief or ordered by a supervisor not to work extra employment, then there could be a denial, yes.
Okay. Do you know let me see. I'm going to move on to a different subject. I want to know about the actual, I guess, atmosphere in the police department on whistleblowing, and whether that is welcomed or not in the department.
Whistleblowing in the sense of someone who comes across misconduct or becomes aware of something, we tell our people and we train, and there's an atmosphere of allowing whistleblowers, encouraging whistleblowers to come forward and to report that conduct.
Okay. And how do you encourage it?
Well, we train, and we give periodic training every few years, and I'm speaking specifically in the area of, for instance, harassment law. Every few years there's updated training in harassment law. The cadets get harassment law training in the academy.
Okay.
And we also have posters placed all around the department about sexual harassment topics. We also have a unit dedicated to taking in complaints separate from the Internal Affairs Division,
Okay.
the Alternative Dispute Resolution Unit.
Okay. And are there any awards given to anybody that, say, complains after they notice behavior that or conduct that is unbecoming of the police department or the police officer?
I cannot think of any.
Okay. And you stated that that you have training, and there's posters, and this is related to harassment, sexual harassment. Is there anything related to use of force or use of excessive force?
So we spend a lot of time making sure that each officer uses force reasonably, but we also tell them that it is incumbent upon them by law, by ethics, that if they see use of force that is improper, they must step in. They must stop the force. Once a suspect complies, the force must stop, and that is the message that is given to the department.
Okay. And how is that message conveyed to the officers?
Sure, it's given in use of force training, or as we now call response to resistance training. It's also covered in going over the federal statutes that have to do with civil and criminal liability that can attach whenever an officer fails to act, when they see another officer using excessive force and they fail to act to stop it.
Okay. And what if they're not able to act and stop it? What if it's just a one-time event? For example, like the shootings. Officer can't stop the person they witness shooting somebody from shooting because it's pretty much done once they stop shooting, right?
I'm sorry, ask again?
So what if an officer witnesses a person using excessive force or unreasonable force, and the officer cannot stop it? What is the response in that case? I mean, if you understand what I'm saying, how does the officer respond if they cannot stop the force?
Sure. The officers are still told to report that conduct. They are trained on the federal statutes, again, that can attach civil and criminal liability of even having the knowledge that excessive force has been used, and they have not reported that excessive force to the department.
Okay. And out of the 5,200 officers that are currently in the force, about how often have you had an instance where officers actually are reporting somebody they work with for what they believe to have been unreasonable use of force?
I don't know a number.
Okay. Is it so many that you can't remember? You can't state a number?
I don't have a number. I don't know.
So it could be none, right?
No, it's not none.
Okay, so there has been officers to report unreasonable use of force.
Yes.
Is that right?
Yes.
Okay. But you don't have a number?
No.
Okay. And how was that responded to when the officer reported, or when an officer reports what they believe to be unreasonable use of force? How is that responded to by the department?
The department takes it extremely seriously, and
Okay. What does that mean?
that means they initiate an investigation.
Okay. And then what else?
They initiate an internal affairs investigation based on the officer's information, excuse me, and depending on the specifics, if it's appropriate to open a criminal investigation, that would be opened as well.
Has that ever happened?
Which one?
A criminal investigation pursuant to an officer expressing the need to report use of unreasonable force.
I cannot think of a specific case, but I'm sure it's happened.
Okay. And what happens to the officer that reports the unreasonable use of force, in their opinion?
What happens as far as what?
I mean, are they just go back to their job and they're not used anymore? What happens with that officer?
They continue on the department. They keep doing their job.
Okay. Is there any type of protection in place for them?
Well, if the department thought that that employee needed to be, for some reason, shielded, sure, the department would offer shielding, but shielding is normally in the context of a harassment case. I've never heard of shielding having to be used in a use of force case.
Okay. Is that because there's not a lot of use of force complaints or reporting?
No, there's actually, there's a fair amount of use of force complaints. That doesn't mean that all of them result in some type of shielding or anything like that.
Okay. So you said there's a good amount of use of force complaints by other officers that have witnessed other officers using what they felt was unnecessary use of force, correct?
May I object?
A reasonable use of force.
This states the testimony fair.
No, I'm speaking generally that there are many use of force complaints.
Okay. And so you're not talking about officers complaining, correct?
Correct.
Okay. As far as officers that make the complaints, is the reason why you're not aware of there being a need for a shield for those type of officers because there's not that many complaints by
Well,
officers?
Asking whether they need shielding assumes that the officer's in some type of danger of retaliation, and we just don't have that issue.
Okay. But you do have that issue with harassment, correct?
Well, in an abundance of caution, many times either the victim or the potential harasser will be shielded. In other words,
sometimes the harasser is shielded?
I guess I should put it this way: in order to shield the victim, the harasser may be moved to another
Okay.
assignment, which in effect shields the victim.
Okay. So when you say shielding, you're saying that the officers are separated from one another?
That's correct.
Okay. Does shielding mean anything else other than that? Than the separation?
Is shielding anything other than a separation?
Yes.
It also includes what we call a no contact order, so that the harasser cannot contact the victim.
Okay. But we don't have this being used in the context of use of force complaints, correct?
I don't think we've ever found the need for it.
Okay. And is there any type of accommodation or award for an officer that brings to the attention of the federal violations, state violations of excessive use of force, unreasonable use of force by another officer?
Well, I think there was a similar question to that. I'm not aware of an award that has been given for that.
No, the other question was different. I asked about whether there was an award for the use of force that was reasonable the question I'm asking now is whether an officer who actually reported what they believe to be unreasonable use of force, has there ever been an award for an officer in that context?
Not that I know of.
Okay. Is there an award available?
Sure.
What's the name of the award?
Well, it could be a chief's commendation, it could be a supervisor's commendation.
So just an accommodation?
Yes.
Okay. So nothing specifically named or a special award for an officer that has went above and beyond what they're, well, I wouldn't say above and beyond, this is what they're supposed to be doing, but has stuck their neck out and actually reported a fellow officer, correct?
Most actions that police officers take that garner award, there's not a specific award for it. They
Okay.
receive a commendation.
Okay. All right. And tell me what is, so there's not really any true benefit for the officer, to report another officer who has, they believe, has engaged in excessive force, correct?
I would not agree with that.
Okay, so tell me why you wouldn't agree with that.
Well, number one, it's the right thing to do
Okay.
to report, and there's a lot of internal satisfaction for an individual in doing that.
Okay. Right thing to do.
Absolutely.
And tell me another benefit for that officer in working in the police department in reporting activity they feel is unreasonable use of force.
Well, I don't know if we have to go beyond the right thing to do. Police officers do things every single day, not doing it for additional compensation, not doing it for an award, but merely doing it because it is the right thing to do.
Right. So the answer to the question is no, there's nothing, correct?
I mean,
Except
it would-
for the knowing, except for the satisfaction knowing that you've done the right thing, correct?
No, there could be a circumstance where they get a commendation. I'm not going to say the only thing that could ever happen is that they have done the right thing and they have the internal satisfaction.
Okay. And you said that there's an encouragement for reporting the use of force in the department. Explain to me the encouragement.
Well, encouragement doesn't capture everything, and it's actually codified in our policy that they're supposed to report. Obviously, we talked about it's codified in law, and they're made aware of that as well.
So other than it's the right thing to do and that it's the law, what encouragement is the department doing to make sure that these officers are understanding that that's what the department wants them to do, like kind of like the posters with the sexual harassment? Is there anything else that the department does to encourage reporting what the officer believes to be unreasonable use of force?
Training and policy.
So there's nothing that's done to encourage them, correct?
May I object? Argumentative.
Yes, they're encouraged through training, policy, and law to report use of force.
Okay. But there's no meetings about it. There's no posters. There's nothing to that effect. Like this, in the same manner as sexual harassment is reporting is encouraged, correct?
I wouldn't say there are no meetings because I'm not aware of all the meetings that take place.
That's what I want to hear from you. Okay, that's what I want to hear from you. We have meetings. So that you're saying that there are meetings that take place regarding reporting the use of force when you see it.
No, what I'm saying is if there's a meeting with the TAC team at a local patrol station and the supervisors are reiterating to the TAC team the requirements for the reporting of the use of force, I'm not necessarily going to know about that.
Okay.
But that would follow along with the training that we give. And yes, I'm sure there are meetings going on about that.
Okay. And so you have no concerns about retaliation with these officers that may want to report use of force against another officer, correct?
That's correct.
Okay. And tell me the process of, I think you may have, I won't ask that question again, of reporting. If Officer Mulhood wanted to report Officer Harris, how would he go about doing that?
May object to incomplete hypothetical.
And would your question be to this specific situation?
Yeah, sure. I mean, because to me it seems like he's in a certain position because here he is with his partner. He may, if he were to have witnessed what he believed was use of excessive force, how would he go about reporting that use of excessive force?
He would report that to the Internal Affairs Division when they came to the scene of the police shooting.
Okay. And would they be separated at that point?
I don't know if they were, but typically you're going to separate witnesses to a scene, yes.
And the reason why I ask is if Mulhood wasn't separated, how could he safely report another officer, Harris in this instance, shooting somebody when he's right there listening?
Well, number one, I guess I'd have to get from you at what point you're talking about them being together, because the investigation of a police shooting is going to take a couple hours to several hours.
Okay.
So I think it would be quite easy for one officer to step to the side, away from the other officer, if they happen to be in the same vicinity at that area at that time, and speak to any supervisor on the scene to report the excessive force, speak to the internal affairs investigator, tell the homicide detective about it, anybody.
Okay. So the officer would have to step to the side and seek out somebody to convey the information to that arrives on the scene, correct?
Well, he doesn't have to, but best practice is to separate the witnesses once you have a scene that's under control. Obviously, right after a shooting, if you still have suspects that are in custody or whatnot, it's not going to make sense to try to separate the officers at that moment. Once the investigation team gets there and there's no danger from a suspect on the scene, then practice would dictate that the witnesses would be separated.
Okay. What type of mechanism does the police department, I guess extra employment department, have to keep track with their officers that are on extra job assignments or extra off-duty job assignments?
So there's a system, the extra employment system, which is available to officers through the department intranet, and that is how they enter their permits, and that is how the extra employment office reviews the permit.
Okay. So the extra employment office reviews permits. That's how they supervise the off-duty officers that are working extra jobs?
Well, to supervise someone on an off-duty extra job, if there are a certain amount of officers, there'll have to be a supervisor actually on the scene.
Okay.
And at
How many?
I think it's either 4 or 6. I'm not exactly sure.
Okay.
I don't remember.
But at least 4.
Correct.
Okay.
And at this time, we also had a system called the Classified Time Entry Work System,
Okay.
whereby an officer would have to log not only his or her on-duty hours, the hours that they took off for vacation or other types of compensable time, but they also had to log their extra employment hours.
Okay.
So a supervisor was mandated to check that weekly report,
Okay.
and that is another way to check and see what officers are working and when they're working.
Okay. And you said it's called the Classified Time Entry System?
Classified time entry work system.
Work system. And was that in place in 2015?
It was.
Okay. And is it in place now also?
It is not.
Okay. I thought there was some change there. What was replaced? Sorry. What replaced it?
What replaced it is a web-based application where an officer has to log in when they start their extra employment, and they have to choose the actual permit they're working under at that time, and then they have to log out of that extra employment when the job is over.
Oh, okay. And on this system, the classified time entry system and the web-based system now, is that where they can find out what jobs are available for open extra jobs as well? Is there a poster board or something like that on there?
No, there may be private ways that they find jobs, but there's no department-sanctioned way to find a job.
So what if I, as a private person, business, want to hire an off-duty officer to help me out at my business? How do I go about doing that?
A lot of business owners will just call their local patrol station, or they may find the number for the extra employment office, and typically when you call one of those two, you'll eventually get an officer who wants to work the job.
Okay. So if a person were to call down to the main Houston Police Department number and ask for help with their business, I need, a security officer to work off duty, they would be directed to call either their local station, is that right, or the extra employment department, is that right?
I'm not sure how downtown would handle it. It probably depends on who's picking up the phone, because we don't have a specific policy or practice on handling those calls.
And what about extra employment? Whenever extra employment receives that phone call, how do they handle the request for an off-duty officer to work for a private entity?
How they handle it, I'm not really sure. I don't work up there, and I'm not sure how they run their practice.
Okay. Is there any handbooks or guidelines or anything that extra employment would use to respond to that type of request from a private entity wanting services?
I'm not familiar with their internal standard operating procedures, so I don't know if that's included in their SOP or not.
Okay. All right. And let's see. So there's no way to keep there's no mechanism in place currently or in 2015 to keep track of off-duty officers working other than the classified time entry system and the web-based system now, correct?
I wouldn't say there's no other way.
Okay. What are the other ways?
Well, if an officer is working a job that requires a supervisor to be present, many times, even if it's a job where a supervisor is not required to be present, he or she may talk about the job to other officers, maybe even their supervisors, so people know about the extra employment. And if an officer is attempting to work a job without a permit, then that is a violation of department policy.
Okay. And what happens if somebody were to violate the policy in that manner?
Sure. An internal affairs investigation.
Yeah, working without a permit.
Yes.
I'm sorry, you were saying.
Yes.
So an internal affairs investigation would ensue?
An internal investigation, internal affairs investigation would ensue to determine whether or not that person actually violated the policy.
Okay.
Let's take a break.
You ready for a break? Okay.
So, on the record, the time